purposes. So for that reason, the video stream of the audience will be kept off. Please feel free to type in your questions and comments in the chat box or the Q&A box at the center bottom of your screen. And please mention if you would like me to speak or if you would like me to read out, and also which of the panelists you're addressing your question to. So as a part of the ongoing conversation in the workshop, we've addressed different questions related to concepts and ideas, and how we might think of writing more inclusive, egalitarian, and diverse histories of ideas. This evening, we will focus on the genealogies of legal ideas and the idea of law in itself, and ask, how can we think of a global and comparative history of law? What does a global turn in social sciences and humanities scholarship offer for legal histories? How can we move beyond the categories of nation and the modern when thinking of histories of law and legal concepts? For this conversation, we're joined by Professor Caroline Humphries, Professor Timothy Lubin, and Professor Patrick Olliville. Thank you, all of you, for joining us. Professor Caroline Humphries is Professor of Medieval History at the University of St. Andrews and L. Betts-Lea Global Law Professor at the University of Michigan Law School. She is a director of the Institute of Legal and Constitutional Research at the University of St. Andrews and has co-founded the MLit degree in Legal and Constitutional Studies. Professor Humfress has published widely on legal history, law, and religion in late antiquity, and is currently finishing a monograph, Multilegalism in Late Antiquity, for Oxford University Press. She has also published more widely on the history of civilian legal traditions, especially in relationship with empires, both ancient and modern. Thank you, Caroline, for joining us. Professor Timothy Lubin is the Jesse Ball Dupo Professor of Religion and Adjunct Professor of Law at the Washington and Lee University. He has taught earlier at Harvard University and University of Virginia. He is an historian of religion and law of South and Southeast Asia, working with texts and inscriptions in Sanskrit, Prakrit, Old Javanese, and Old Tamil to study the formation, spread, and transformation of concepts and institutions in ancient and medieval periods. Thank you, Tim, for joining us. Professor Patrick Olliville is Professor of Sanskrit and Indian Religions in the Department of Asian Studies at the University of Texas, Austin. He's an Indologist, philologist, and scholar of Sanskrit literature whose earlier work has focused on the ascetic and monastic traditions of India. He has published several editions, translations, and studies of ascetic texts and institutions, such as the early Upanishads, the Grihastha, the Dharmashutras, and the Dharmashastras. Thank you, Patrick, for joining us. Professor Humphries, Professor Lubin, and Professor Olliville, along with other scholars, are working on 2 forthcoming volumes on comparative histories of ancient law to be published by Cambridge University Press. The project aims to provide a comprehensive and systematic comparative approach covering all legal traditions of ancient Mediterranean, Near East, India, and China from the earliest attested evidence to the 6th century AD. Its main aim is to investigate the ancient legal orders or systems, namely legal structures and/or traditions and structures, or lack of thereof. In this respect, the project's primary concerns are those of conventional comparative law. However, where appropriate, they adopt broader approaches which have received increasing attention from ancient historians and scholars of ancient law in recent years. One of the most inspiring things about this project is its emphasis on close collaboration and teamwork, and the way in which the comparative element is built right into the framework of the various chapters, about which I'm very excited to hear more from the 3 of you. Our dialogue will focus on, but of course not be limited to, this collaborative project, which addresses many of the questions we have debated about comparative and global history methodology for thinking about ideas and institutions in the last 2 days of this workshop. Thanks again, everyone, for joining us. We will be in conversation with Dr. Milinda Banerjee and Dr. Kresimir Vukovic. Thank you, both of you, for joining us. Dr. Banerjee is lecturer in history of modern political thought and political theory at the University of St. Andrews, and he's the program director for the MLit in Global Social and Political Thought. He specializes in the intersections of Indian and global intellectual history and political theory. He's the author of The Mortal God, Imagining the Sovereign in Colonial India. He has co-edited the volume, The Transnational Histories of the Royal Nation, the forum called Law, Empire, and Global Intellectual History, in the journal Modern Intellectual History, and the special issue, The Modern Invention of Dynasty, in a Global Intellectual History in the journal Global Intellectual History. He's an associate editor of the Journal of Political Theology and the founder editor of 2 series with De Gruyter titled Critical Readings in Global Intellectual History and Transregional Practices of Power. Thank you, Milinda, for joining us. Dr. Vukovic is Alexander von Humboldt Fellow, Research Fellow at the LMU Munich and Review Editor of the Journal of Indo-European Studies. He did his doctorate in classics at the University of Oxford with a thesis on the Roman foundational myth and the festival of Lupercalia. He was then lecturer at Oxford Classics and started a postdoctoral research project on the River Tiber as fellow of the British School at Rome. His research interests include environmental humanities, eco-history, and he's passionate about Greek and Roman mythology, which he has been researching and teaching for many, many years. He has published widely on these topics in journals and edited volumes, and is currently finishing a book on Lupercalia and the Roman foundational myth under contract with De Gruyter. Thank you, Kresho, for joining us. And as it is customary, I am a doctoral candidate at the Faculty of History in Cambridge. I completed my bachelor's and master's degree from President's University, Calcutta in history. I was also an exchange student at Sciences Po Paris, and I was a Charpak Fellow where I completed a certificate in European Affairs and B1 French. For my master's degree, I wrote a dissertation titled Beyond Local and Global Narratives, Concept Histories of the Boidha Community in Colonial Bengal. My PhD project in Cambridge is tentatively titled A History of Conjugality on Patriarchy, Caste and Capital in the British Empire between 1872 to 1947 and is funded by the Cambridge Trust and Rajiv Gandhi Foundation. I would now like to invite Dr. Banerjee to initiate our conversation this evening. Thank you, everyone.
Thank you very much, Shuvatri, for that wonderful introduction. And thank you to everyone for being present here. In Bengali, we have a phrase, Chande Hat, the marketplace of moon. So thank you all for being here. I'll just read out my first question/comment, which basically asks the question inspired very much by your project on what is law and who is sovereign. How does a comparative history of ancient law, as you are creating, expand our understanding of what is law, and relatedly, who makes law? Histories of law and legal thought in the modern era often focus on state law, privileging implicitly or explicitly statist perspectives of legal positivism, law as the command of the sovereign. Of course, when we look at non-Western perspectives and global history, we sense a very different historical and ethnographic reality. In my own research, I have shown how so-called lower caste or Dalit and so-called tribal or Adivasi communities in India, like the Rajvanshis and the indigenous people of Tripura, self-consciously legislated community norms, labeling them as Vidhi and Dharma. This mode of subaltern self-legislation constituted, in Rajvanshi legal thought, the infrastructure of Atmashasana, self-rule. I would categorize this as a kind of subaltern constitutionalism enunciated by exploited peasant communities. It was through subaltern political and legal pressure exerted in legislatures as much as through more militant struggles that the Indian legal political system came to be decolonized and democratized across the 20th century, making welfareist provisions for lower caste and Adivasi communities. Intellectuals originating from subaltern caste backgrounds, such as the jurist Radha Vinod Pal, critiqued Indian as well as Western models of state sovereignty to argue that justice had to be rooted in much broader cosmic moral norms, exemplified for him by the Rig Vedic Rita, as well as in actually existing social struggles by populations oppressed by racial, class, and caste hierarchies across the world. What all of this demonstrates is that legal thought needs to encompass far wider landscapes than modern legal and intellectual historians have generally admitted in practice. Returning now to your project, I would ask you, what can scholars of antiquity contribute to this? I'm thinking of the wide understandings of cosmic moral law that are ubiquitous in ancient societies, such as Rita in India, Themis and Dike in Greece, or Jus in Rome. I also wonder if there are broader arcs of connected Indo-European frameworks of cosmic moral law that can be excavated here. The works of Antoine Meillet, Marcel Mauss, Émile Benveniste, and others remind us of such ancient and connected conceptual genealogies. Can such genealogies problematize, if not dissolve, the boundaries between so-called law proper and wider structures of social exchange, reciprocity, and norm building? Perhaps such ancient histories can also decenter questions of sovereignty in the sense of going beyond a fetishistic Carl-Schmittian focus on who is sovereign, who decides, to much more interesting questions about social interdependence. To conclude briefly, can we think with ancient law about challenging the dominance of state sovereignty and anthropocentric positive law today, and think about alternative horizons of law that emphasize the interdependence between humans and non-humans in the cosmos that we commonly inhabit? Can such comparative understandings broaden our definitions of the political in thinking about interdependence between humans and non-humans and our common obligations to each other, and especially to subaltern beings?
Should we have responses now? We can start with Caroline.
So thank you very much, Milinda. There is so much there to unpack, and I'm not even going to pretend that I can unpack it all. So I thought by way of response, I think my first point would be that having kind of been involved in this project now for too many years, probably, what it's made me do is to question what I think law is today, and also what I think state sovereignty is today, and also to see that the concepts that I work with as a historian aren't even the kind of relevant modern 21st century concepts that most kind of lawyers, and especially lawyers who work in the international sphere and the global sphere, work with. So I'm just going to kind of start there and then maybe tell you a bit more about the genesis of the project and kind of what I think we can maybe contribute in terms of thinking about ancient law. So first of all, what we mean by law and state sovereignty today, I am increasingly realizing that, you know, when I think of the state and sovereignty, I am kind of imparting this idea that's been developed out of a neoliberal network governance system, that regulatory capitalism is kind of there at the back of my head, even though it's not conscious. So I spend a lot of my time trying to unthink all of that, because of course that doesn't apply to the ancient world. And that also might explain my next point. So when we began this project and we started looking for kind of comparative frameworks that already existed, we went back to late 18th, 19th century scholars who compared ancient law and legal systems, but they did this from within, you know, as you well know, progressivist and teleological frameworks of development. So I think my first point about what we can contribute is, first of all, and I think that modern constitutional lawyers, and especially kind of lawyers who work in this global or international field, are already there with this. But our project says that, you know, we have to reject these kind of progressivist teleological frameworks of development. And even within, you know, distinct ancient legal orders. So I remember lots of very vibrant conversations, for example, about ancient Mesopotamia. And the idea that you can't think about law in ancient Mesopotamia in a linear way. And Marta Roth, who's one of our wonderful contributors, said that for Mesopotamia, when you're thinking about law, you have to think of several different moments in time. So I think this idea of, you know, not putting everything onto a progressivist teleological framework that ends up with the state and the sovereign is something that we see even if we just stick within the huge time frame that we are dealing with, which, you know, we bundle together and call ancient. Second thing that I think we can contribute is just the complexity of law, thought, and practice across these ancient societies and traditions that we're dealing with. Ancient law is not primitive law. You know, in fact, my one takeaway point from this project, I think, would be this. You know, there are incredibly complex shifting distinctions between positive rules, morally driven principles, and the question that you asked, which I hope we'll come back to, about human and non-human relations. You know, I think that these are really complex thinking going on in these ancient societies. Third thing, and then I'm going to hand over to Tim and to Patrick, but just this idea of decentering the Roman law and the legal tradition, which sounds very odd from someone who's been trained, you know, in that kind of Roman legal tradition. But it really dawned on me that, you know, at least in the kind of modern Western sphere, we tend to prioritize Roman law in the legal tradition because, you know, we kind of inherited it through the West, and a lot of time and expenditure from great minds has been undertaken from the Middle Ages onwards into making that look like a very natural, progressive kind of development. So with this project, the way that we literally set up the collaborative teams was an attempt to de-center Rome. So, you know, our absolute main point of beginning point was that we would not have every chapter with Rome being the one constant which everything else was being compared to. So I'll leave it there and hopefully we can come back to some of the other points. Thank you.
I guess it sounded like you were passing the baton over to me. So I'll say a couple things that I had in mind to begin with. First, I think it's important, and especially for people who don't look at ancient law a lot, to bear in mind three sort of axioms for trying to answer a sort of question of what does ancient law tell us about the nature of law. The first is that our access to ancient law, like ancient anything, is fragmentary and lopsided in the extreme, though in different ways in different cultural spheres. So law not only looks different, but maybe is different across these different spheres. Secondly, elite viewpoints are even more overrepresented than in later eras. That doesn't mean that non-elite agents weren't making law. We just have even more trouble seeing them. The third axiom is that this requires, maybe this is in two parts, systematic attention to hearing what the authors of these texts and documents didn't mean to say about themselves and about non-elite subaltern groups. And it means making the most of the surviving documents as opposed to, say, codes and legal discourses, even sources that aren't strictly speaking legal. So we had a lot of wrangling about what sort of things we were actually going to be paying attention to when we were first having discussions about how to proceed at the very beginning of the project. Most ancient legal texts were authored by power holders. This is also largely true of documents, although it's there that we hear a wider range of voices and concerns, just as is true in a modern context. If I could just step back to think about some of the things that struck my eyes most forcefully, or my ears most forcefully, when the horizon of ancient law is extended beyond Greece and Rome. There are three points of interest that I think are worth discussing further. First is the fact that the legal definition of citizen, which is so all important in the context of Greek and Roman law, turns out to be a peculiarity. I mean, it's very hard to find anything exactly comparable to it in any of the other legal traditions that we were looking at. Mostly heuristic social classifications of other sorts seem to have sufficed. So mostly the citizen seems to be a loosely conceived default status of those with full rights and obligations vis-a-vis of society and the state, and is distinguished most concretely from groups deemed alien or foreign, some of whom are simply designated by ethnonyms. Considering the centrality of citizenship in defining civil rights and border control in modern nation states, the seeming informality of how civil status was conceived in these ancient societies outside of Greece and Rome is really notable, really striking, but perhaps also misleading insofar as a range of other more particularized statuses served a similar purpose, that of householder, guild member, resident, a villager or something like that. But nevertheless, we don't have that sort of, we certainly, if you go looking for the citizen outside of those contexts in these other realms of ancient law, it's a bit hard to find. So a second thing that I would like to emphasize that the comparative study of ancient law has really brought home to me is the extraordinary complexity and centrality of unfree statuses, as say, what the sort of things that get lumped together under the term slavery in a lot of modern discourse. And of course, there's a whole field of study addressed to that. Actually, the questions we were presented didn't actually bring this up, which I found striking because it just seems so obtrusive in ancient law. So much of the first thing, in fact, okay, maybe some of these non-Greco-Roman traditions didn't have citizens, but everyone's talking about various forms of unfree labor. And one of the things that I found striking then too is that let's say if we go back to some of the landmark studies of slavery, I'm thinking even Moses Findlay, he says the real slave society, true slave societies were very, are really just Greece, Rome, and then you move immediately to the colonial period. You've got, the Brazil, the Caribbean, and America. And it's all framed very much in terms of racial and ethnic separateness and the notion of a sharp break between slaves and the rest of society. But when you, again, what I found, what I think one cannot help but find is that actually the range of phenomena is much broader, which raises a lot of interesting and maybe unsettling questions. One of the most important of these, though, is this question of, in all slavery situations, there is this conundrum of people being, on the one hand, the issue of their personhood comes up, right? Even if it's dismissed or nullified. And on the other hand, they are property or treated as property. So you have this sort of paradox of someone who, people who become objects of legal action or subjects of legal action, in fact, sometimes, who are at once property, treated as property, and also to some extent treated as persons. And well, so different analytical systems have been proposed. You had Orlando Patterson's extrusive versus intrusive forms of slavery. We can talk about that. There was James Watson and Anthony Reed have talked about open versus closed systems. But the truth of the matter is that there, right across the ancient world, you've got so much diversity going on there that it becomes rather tricky to try and then take some sort of analytical lesson from it to think about the forms of servitude, unfree labor, and so forth that you have in the modern world. Or I think it also closes our eyes to some forms, right? To not take account of penal servitude or debt servitude, which were so common in the ancient world. The third point that really leapt out at me, and I suppose it's because I'm a professor of religion, I was trained in religious studies, is the fact that in studies of ancient law, there's been so little discussion of religious law. And one of our early meetings, I recall some somewhat testy exchanges, at least it seems so to me, over whether and to what extent to include discussion of religious law. I mean, basically, for those steeped in the Greco-Roman tradition, religious law just fails to rise to the status of law. It's like law only in a metaphorical sense or in a rhetorical sense. And of course, the question that in theory I'm responding to here is actually about to what extent do concepts like use and rita inform that derive from antiquity? What do they tell us about the nature of law? Well, in fact, in some sense, they're extrinsic, they're external to law, the business of law. Those are lofty ideals which get trotted out to justify a legal system. Every legal system wants to present itself as just, but that are not actually central to the working of law. So one of the things that I wanted to that I came away with is the question of basically, I've come increasingly to think of a distinction between law in different spheres, I'm tempted to call them polities, right? So, I mean, normally we take the word polity to refer to a state-like sort of social arrangement, institutional arrangement. But I think religious law, religious legal systems have their own polities, but they're not territorially based. They're in some sense trans-state or trans-regional legal regimes. But they apply to, there are people who are subject to those, to that law, and for whom there are legal implications. So I think there's some more very interesting theoretical questions to be addressed in how we think of what is the jurisdiction of religious law? How do we talk about that? How does it overlap with the law of a particular community or a particular state on whatever scale, whether that's just like a city or an empire. And also there's a third factor here, which tends to, again, complicate things by getting overlapping with these other two spheres, which is that of custom and customary law. Another huge debate, not just in the study of ancient law, but in the study of law generally, legal studies, is what, is there such a thing as customary law? Does it have to be written down in order to count as law? And what happens when it does get written down? Does it cease to be custom? I mean, one of the issues that comes up in the colonial era are the colonial powers in putting together new systems of law for the territories they're governing, trying to recognize and incorporate elements of customary law from the governed peoples, and of course making a total hash of it generally. But this isn't just something that happens in the colonial era, so to speak. I think we can actually see this happening in the antiquity itself, where custom gets invoked as a source of authority. So, so in that sense, we've got the state as the sovereign actor, right? Then you've got religious legal authorities claiming another kind of sovereignty, which is competing and in tension sometimes, even if there are also sometimes efforts to sort of fuse those two spheres. And then you've got the authority of custom, which is perhaps the most, the one with the best claim to somehow represent the people or the grassroots. But even there, of course, there are hierarchies involved, right? So I would say those are the three big issues that the study of ancient law, embracing the rest of the world beyond the Mediterranean, has really brought home to me.
Okay. All right, I'll be since much of has been said already, I don't want to continue repeating what has been said. But I think it is important to recognize and acknowledge how small our project is. One thing we need to realize is that our project is a text-based project. Whatever is not written down is not included in our. And I'd say 90, 95, 99% maybe of all laws of ancient times are therefore not included in what we are doing. And Milinda's work in the anthropology of law, if I want to call that, we don't know. That's not included in what we do. And since things are written down, we are dealing with an elite kind of reflection on law. So that's one thing. We need to recognize the limitations of what we have done. And of course, why we didn't go into the other area is not because we thought it was unimportant, but because we had no access to that, right? It's just not there. That's one. And second, and this, I wrote one chapter and I'm now revising, I'm editing some of the other chapters. It's very clear is how different the focus of various legal systems are. Mm-hmm. If you look at China, for example, you hardly get any procedure. The legal procedure is almost not there. It's mostly with regard to the connection with the state to the people. And as somebody said very clearly, it deals with punishment. How do you punish people who break the law, right? And that's a state concern. Most of what is concerning India, on the other hand, most of Indian thinking deals with how do you resolve public dispute, private disputes. Right? So it's a dispute resolution. And then legal procedure looms large in the discussion. And much of Indian, we call legal texts, are actually meta-legal reflections, jurisprudential reflections on law, rather than law itself. So there's a very different, the apples and oranges here we are dealing with in India and China. Indian texts were written by sort of jurisprudential experts, rather than lawyers or judges or people who are actually practicing law. China's were written mostly at the imperial level, it's a sort of a state-sponsored kind of thing. When we come to the Near East, these are mostly, I don't know, I'm sure Caroline can talk a lot more about it, but we have very different remnants here of law there, right? And there we can see how actually particular cases were resolved, right? Which we don't find in India. So this is different. So that's the other thing I feel, that we have very different kinds of sources. In India, again, and this will interest Milinda's, okay, law, and this, just aside, we are trying to define law, but we are trying to define an English term. This English term is not found anywhere in the ancient world, right? So in a sense, we are trying to translate into law some other factors that we find over there, terms, etc. You brought the word rita or dharma. Yes, they're connected. Their semantic range somewhere overlaps with the semantic range of law, but there is no coincidence. They don't coincide. So that's the other issue I think that we find. With regard to law in the sense of non-state entities, Tim talked about polities that are not region-based. One thing interesting in India is that the law that we have recognizes the validity of these subaltern or sub-state entities. So they talk about Desha Dharma, Dharma of regions. jati dharma, dharma of castes, or kula dharma, dharma of large family groups, or even corporate law, Shreni dharma, right? And the corporate law, you have the most visible example of corporate law in India, one of the earliest law codes of India is the Buddhist Vinaya, right? Which is basically a religious corporation constructing its own legal system. So that's, I think, where we have examples within the extant textualized forms as they talk about other things that we don't have access to. So that's, in a sense, we do have a tangential connection. So that's one. Tim has worked on this similar code called Vishnu Sena's code, right? Which we should not allow Tim to talk about it because he'll take 2 hours to talk about it because he has been working on it so much. Again, a corporation of what are they? Traders, right, Tim?
Yep.
Traders who made their own laws and got the imprimatur of the king to say, okay, you all can do that. Okay. And with my last point is where I want to raise a red flag with regard to Milinda's use of the word rita and dharma with regard to some other way of looking at it. Historically, though, these sort of cosmological concepts used with regard to law has been actually used to defend the status quo, to actually defend oppression, defend the prerogatives of the upper classes, right? So that's a double-edged sword, these kinds of things. Yes, it is not modern, and therefore we may think, I think we lost somebody. But
yeah,
Milinda,
I think he'll be able to join back in. Yeah.
Okay. Anyway, so that we need to be a little careful about that because many of these so-called cosmological concepts have been used extensively in India to defend the status quo of the caste system, especially, right? The hierarchical system. And the other thing is, and this is a question that I'm not a expert in this area. Milinda uses the term anthropocentric and how you want to get out of that. Depends on how you interpret the term centric, right? Anthropocentric meaning always dealing with people, or is it coming from people? If we are humans and we are producing law, it cannot but be anthropocentric. You don't get dogs or cows or lions making law. We make law and we never consult these people. We don't ask lions how they want laws to be constructed. So in that sense, it is an anthropocentric law. And even when we give religious personality to an animal, it is we who impose that on them and say that they are within our structure. You have this done in India with regard to divine images, right? The temples and temple images are viewed as legal persons. And you talk about rivers now, right? Yeah. So humans can, give legal recognition as persons. And we find this also in corporations, right? Corporate law they take them as some or other persons in today's law. Yeah, but I'm not sure whether that makes it non-anthropocentric. That's what it's just a question rather than an answer. With that, I'll end.
Rishu, shall we have the next question from your end?
Of course. So my question actually follows on from Milinda's, and I'm glad that several of you have already addressed parts of it. So it concerns the non-human in law. And it's about the way law is used to conceptualize the non-human in various traditions. So who owns rivers, lakes, and wild animals in Roman, Hindu, and other legal traditions?
I wrote an article on Virgil's portrayal of the stag of Sylvia in Aeneid Book 7, which is a crucial scene in that great Roman epic. And the way he uses the Roman concept of res nullius, which was applied to wild animals, rivers, and lakes in various periods. Similarly, Milinda wrote about the deer belonging to the person who wounds it in the Code of Manu, and how the legal perspectives on the wild influenced Indian conceptions of property and sovereignty. And we are planning to write a paper together on this joint, perhaps some common elements in between, and how the perception of deer can be compared in the two cases. So it would be an enormous help if you can talk a little more about the role of nature in different legal traditions, how it's perceived and conceptualized, and how it influences the view on property and sovereignty.
Shall we start with you, Caroline?
I was just thinking that this truly is Roman legal imperialism, isn't it? That the Romanist gets the first stab at the question. It will always be there.
Reverse the order from the next round. Because we descend to Rome, so we'll reverse the order from the next one and start with Patrick.
Excellent. So I have to say, Kresimir, thank you so much for asking this question, because I've spent quite a lot of time working on natural law and ideas of nature in Roman law. And never ever have I thought of this in terms of the way in which law is used to conceptualize the non-human. So having received your question a week or so ago, I have been trying to think about this. And my first response would be to take it back again to the 19th century. So I think something happens, especially German scholars working on, Roman legal texts, to pick up on Patrick's point. Something happens in the 19th century and they start thinking about human relations over commodified goods as a kind of patrimonial law. Now, if we begin to think in those terms, what these 19th century scholars kind of accept is that this patrimonial law is universal, that it somehow compares with a public law which relates to the peculiarities of different people, and a family law which is about private relations which are unequal and mutually dependent persons. Now, first point I think to make about this, to go back to, again, Patrick mentioned China, and I have to say all the way through this project, China has been the point where, if you had a cup of coffee in your hand, one of our China experts would say something and you would drop the coffee. It was just like, what? I remember one occasion where one of our Chinese legal experts said that China had no concept of private property. And I can't remember what the rest of the discussion was, because I was just sitting thinking, how can that be possible? How can you not have a concept of private property? But that's because I was trained as a Romanist, and I've read all these 19th century German jurists who have this very particular frame in terms of human relations over commodified goods. So Roman law, my start point would be to say that obviously with Roman law, you're thinking about property, you tend to be thinking about Roman civil law, which is also what the Roman jurists, the legal experts who developed the civilian system, are thinking in terms of. And of course, that's remedy based. And that's the kind of first point that I would make about Roman law in terms of private relations and this relations over commodified goods. So obviously animals, as you all know, cannot pursue an action at Roman law. And that's not as kind of crazy as it sounds, because of course, if you switch to the Middle Ages, you can try a rat or a cat, but that's not the case in the ancient Roman world. But of course, animals can be subject to Roman law as things, as res, and what this things mean is quite technical in Roman law. It means that they can be the object of a legal act. So to go to this kind of fairly technical concept, the res nullius, when I put your question and kind of went back to the text that I'm used to dealing with in this sort of new way with your question in mind, of course, Roman law is quite sophisticated in terms of demarcating what can be thought of as commodified goods and what cannot. So the concept of res nullius, of course, it also encompasses this technical Latin term res divini juris, so the things which belong to the gods, which cannot be the property of any individual. Res communes, things that must remain in common. So I think there, res nullius has this sort of double sense that one single person cannot own them because they're owned in common, or, you know, that they cannot be owned per se. So they can't be objects of property. So things like light, air, water, and of course, Kresimir, as your example of the deer, shows wild animals. So then I went back to, and this is where I'm going to finish, Justinian's Institutes 215, and had a look at about what Justinian's Institute, so this is the text that was put together in the early 6th century. It's part of the what later became termed the Corpus Juris Civilis. It forms the tradition of civilian law all the way through to our present day. So Justinian's Institutes is a kind of handbook for first-year law students. It's what, you know, your first years are going to be given this and said, right, start here and then go off and look at the much more complicated kind of case-based reasoning that you get in the other texts of Roman law that Justinian puts together. So Institutes 215 talks about peacocks, doves, and bees before it gets onto deer. So I'm just going to read out what it says, because I think this comes back very nicely to this question of human relations over commodified goods and whether the Romans think about animals as commodified goods or not. So it states, some also have domesticated deer who usually go to the forests and return, of which no one denies having a wild nature. So you've got this idea of these deer who nonetheless go off and they're wild in the forest, but they come back. But about these animals that have the habit of departing and returning, I think this is the really interesting bit, a rule was established, so that's amongst the Roman jurists. It is understood to be yours while they have the will to return. What? So if the deer have the will to come back to you, they're yours. But if they no longer have a will to return, they stop being yours and they can submit to new possessors. Then you can almost see the kind of the jurist, you know, the cogs in their brain turning, because they add the bit which says, in addition, it is considered that they stopped having the will to return when they have abandoned the habit to return. So the reason why I think this passage is so interesting is because it just brought me up short, right? Because the deer, according to this Roman juristic thinking, have a will. And it's important when you're thinking about the deer as being, you know, the kind of objects of a legal proceeding to work out what the will of the deer is. And yet the Roman jurist doesn't quite go there, because you can see him, it's always him, thinking to himself, but hang on a minute, how would a human know what the will of a deer is? So maybe we need to backtrack here, and we'll say that it's the will is the habit of action. So Kresimir, I'm not sure that I can really answer your question. I think it's a brilliant topic. This relationship between the non-human and the human, and this idea of what can be commodified through human relations and what cannot be. And my answer from a Romanist perspective would be that I think it's a lot more complicated than I ever envisaged when I was doing my much more kind of conventional work on property and you know, ideas of nature. So yes, let's talk more at some point. I'll hand over now, and Tim, Patrick.
Yeah, if I may, it's interesting that in India, we actually have two different technical terms for animals that are domesticated and therefore subject to ownership, and animals that are not domesticated and therefore not subject to ownership. The former is pashu, that also is an animal that is available for sacrifice to the gods, and mriga, which is a term for a deer, but has been expanded to mean the wild animals, right? So that's the we have there. With regard to rivers and things, it's difficult. There are some places where reservoirs can be actually constructed and therefore owned by somebody, even though it is a water place where there is water. And then there are rivers, you know, that are not anybody's property. And I think there is one, and I have not looked at this very much, but there is a word that often is used with regard to places of water, which is called deva kata, dug by gods. When it is dug by gods, there seems to be what we would call today natural. So a pond, lake, river, ocean. But if you actually can build a little reservoir, dig and have water in your land, we will call it a pond, I guess, today, then it can be yours. Who owns wild animals, wild trees, wild plants? Something peculiar to India is that there were forests, actually wild forests, that were demarcated for particular purposes by the king. So it is like a national park today, right? A national park, you can't own it because the government has said it is now a national park. So you have in India, they have elephant preserves, there are deer preserves, there are timber and or wild things that you get from the wild preserves, including, I assume, fruits and things. And there are others where it is said in the Kautilya's Arthashastra, where the animals are viewed as guests, and therefore you can't kill them. So there's a rather complex series of wild areas that are designated differently. That's one. And with regard to, I think you bring this thing of who owns when animal is shot with an arrow. Manu has a very interesting thing there too, where if you shoot an animal and if somebody else shoots at the same one later, who owns the animal? And it's clear that the person who shot it first, so you can't shoot. Sanskrit says anu with the one after. Shooting after does not create an ownership. But the other thing, again, there's a huge amount of philosophical speculation, not legal, but philosophical speculation in India of ownership. And in Sanskrit, it's called svatva. Sva means yours. Svatva is abstract of that, the yourness or hisness. If I have a cow and I sell it to you, it was mine and now it is yours. Is there a quality in is there an attribute, like Aristotelian attribute in the cow that now changes from me to his? There's a huge amount of work done there, especially in the Navya Nyaya, it's called the new logic theories in northern India, especially. Yeah. Tim, hand it to you.
Okay. Well, you hit a couple of my points already, not surprisingly, but I mean, I think maybe I'll back up for a moment and come back to the question of, in China, there's no private property. I'm not able to say whether I agree with that or not, but I will say that people used to say exactly the same thing about India. And in the case of India, I'm pretty confident in saying that they were wrong. That this whole notion of Oriental despotism, with its lineage back to Marx and earlier, that the king owns everything and everyone else is just paying rent on it. So you can find in India some statements to that effect, but they're always in the context of just praising the mastery and power of the king. It's not really in a context of talking about who owns what. And you also have statements, there's one passage in particular in the context of a ritual, discussion of ritual capacity, whether a king can give away the whole world as a sacrificial offering. It says, no, in fact, he can't. Which sort of reveals the truth of the situation, which is that, well, I guess what you'd say is that there's a sort of slippage going on there between the notion of the king as lord and master and the concept of ownership. So actually, one of the best ways that we can know what ideas were in practice about the ownership of property, of land, and other forms of property in ancient India is through these surviving documents. They were originally documents in the sense of written on a perishable material, such as a palm leaf. But the ones that have survived, I mean, none of those palm leaves have survived from India because of the nature of the climate. It's not like it's not an arid area where you can find ancient bills of sale from Egypt from the 5th century BC or something like that. Nothing like that exists in South Asia. But quite often, certain types of these documents were copied onto metal plates or onto stone. And some of the earliest ones we get from the early centuries of the Common Era, the first centuries of the Common Era, are referring to the difference between royal property and other property, which immediately tells you that not everything was royal property, right? That some things were owned, some land was owned by people, individuals, and some could be owned by the king. And we also have numerous instances then of kings buying property in order to give it to somebody. So again, this is an issue that comes up. There is this sort of rhetoric of kings being the owner of the world, but it's really rhetoric. It's not a literal form of ownership. I'm not confident to say to what extent the same sort of critique could apply to China. Now that you mentioned that, maybe I wasn't in charge of the property chapter, so I didn't formulate a view. But in any case, that's sort of a red herring, I think. What else can we say? I mean, so the slippage allows for rhetorical claims that the sovereign is the owner of the whole world simply by being a master of it, but that's not the same thing as ownership. On the other hand, we can talk about the fact that in some ways, he is a sort of default or residual. He can have sort of default or residual. First of all, there's a whole issue of wild areas, which according to Arthashastra, it does come under the scope of royal authority. Let's say private property that becomes ownerless can escheat, to use the technical term, right? It can, the ownership can be automatically transferred to the king. So that's a situation where we can conceive of the king as having some sort of claim, ownership claim in the background, residual ownership claim. Land can be seized if taxes aren't paid, right? But I mean, if you're going to say that that means that you don't have private property, then private property doesn't exist in the US or Europe either, because I mean, the same thing can happen if you don't pay your taxes. And of course, penal, you get forfeiture due to punishment and other things like that. So the state does intervene in these sorts of ways. But I'll also point out that these early documents we have about, these are mostly related to religious endowments. So land and sometimes other things given to religious institutions in such a way that they become, the state will no longer collect tax on them, and the beneficiaries will acquire a substantial amount of autonomy from the demands of the state. So the very first thing that's often mentioned is that such property will not be liable to escheat. Right. So this residual claim will be abandoned. The money that the king used to receive, and this, by the way, is another reason that kings sometimes were described as owning everything, is because people had to pay a share of their crop or produce to the king. But the Dharma Shastra texts are, they always specify that this is sort of actually a sort of social contract, that it's because the king is defending, protecting people from thieves and so forth. That's the reason he deserves his 1/6 shares, is commonly what the claim is. And likewise, very interestingly, there's once in a while, you'll see the claim that when he renounces that because of a religious endowment, he gets in return 1/6 of the merit of the donor. So let's say someone, a private individual, gives property to a religious institution, land is one of the most common things to give. The king will no longer get his 1/6 share. That will go to support the institution. What the king gets is 1/6 of a merit. So there's sort of quantification of religious merit that goes, I mean, it enters into the economic arrangement there. It becomes a currency in effect. Yeah, maybe, I don't know. What?
No, I was just wondering about Shuvatri. We have gone through 2 of 6. How long do we have here?
Yes, yeah.
You may want to.
Maybe I better stop.
Well, we have such a lot to unpack that I'm not being too stingy about time, but I guess we can go up to 6:45 if that's okay with everyone on the panel. If that's
which is what, 45 minutes more?
15 minutes more. We had till 6:30 originally.
Okay.
Right. 45 minutes from now.
45 minutes from now.
Okay,
yeah.
right. Okay.
Yeah.
All right.
Are we good? Yeah.
We want to go a little faster. Yeah.
Yeah, because this has been so thought-provoking that I really don't want to sort of cut the conversation short in a way. Yeah, so my thoughts will sort of tie up into the conversation because coming in third, I have to incorporate some of the very crucial elements that have sort of come up. I will read out the outline that I have, but I will sort of edit it as we go along. So if law is understood as a tool for regulating human conduct and in turn enforcing certain modes of being over others, then histories of legal concepts and their institutionalization will definitely yield many new insights when it is studied in intersection with histories of patriarchy. The term patriarchy admittedly has a very broad theoretical remit. So to clarify, in this particular context, I'm conceptualizing it primarily as a code of conduct for, to clarify, I'm sort of defining it primarily as a code of conduct for regulating human behavior by determining and normativizing gender roles. When we approach it etymologically as the rule of the father, then the long-during nature of the relationship between law and patriarchy becomes quite clear. So my question to you would be, what new insights can a comparative approach to ancient law provide us with for understanding the conceptual intersections between law and patriarchy? In my doctoral research, I look at the institution of marriage and use this theoretical intersection to trace the ways in which it has determined histories of capital accumulation by regulating private property ownership and inheritance. To elaborate briefly with a comparative example, the corpus of Stridharma literature and the lex from Roman law, both of which were broadly normative prescriptive codes of behavior for women, begs the question, who is the lawmaker here? Is it the husband? Or is it the husband who's also the father of the offspring, enforcing it within the household? Or is it the elder male, the paterfamilias, the grihastha or the grihopati, often the brother or the father of the husband, enforcing it on the widow? Or is it the colonial legislator enforcing it in courts of law to determine inheritance and private property rights? The crucial question which comes out then, which has been discussed so far, is what is law? How do we place religious law and custom in it, as Tim had mentioned a while ago? So to respond to that, my thoughts in my work, I establish a degree of critical intimacy with the concept of law and contextualize it in a liminal threshold between private and public spheres, between male and female life worlds, between human and non-human milieux. On one hand, law is undeniably a tool of dominance for the powerful, but at the same time, these histories of law are scattered with instances of negotiation and dialectical engagement rather than top-down imposition. Keeping this in mind, law, I believe, has been understood in a limited fashion as an institutionalized tool of governance, an understanding that has also shaped much of the elite bias within legal and intellectual histories. So how can we use the methodological tools of comparative history to reconceptualize the very idea of law and overcome these limitations? And in what ways can that incorporate actors and agents from the margins of history within histories of law? The other thing that I will sort of quickly add to that was something I was thinking of when listening to you, is the question of the will that Caroline mentioned when it came to the deer. And so if the deer has the will to return, and if we impose that human, non-human paradigm through the perspective of gender, then the question of agency is the same as the question of the will. And so in that respect, how can we think of the question of agency when it comes to legally defining that agency? Where can we look at the agency of women, of non-human elements within this whole discourse? And since we were responding and starting with you, that wasn't because you were a Rome specialist, but because another Roman system of alphabets dictated that we go alphabetically. But we'll switch the order now, and we'll start with Patrick.
Yeah, it's a great question, and I don't necessarily believe that what we have been doing in this project answers those questions necessarily. It goes way beyond what we were trying to do. But to answer that, I mean, as an individual here, you're right. I think most laws, I wouldn't want to say all, most laws that we know of have patriarchy as its defining characteristic, I think. And it is true with regard to gender roles within society, ownership of property, laws regarding marriage and remarriage, laws regarding widows, and all of that. So that's very clear. One question that I had was this, at least I read between the lines what you're saying, is that that you may be thinking that law that is not state-based, or statist law, somehow is non-patriarchal. I may question that, right? In other words, if you go to tribal law, or if you go to subaltern law, is that non-patriarchal? You may need to prove that rather than assume that it is, right? Because tribes are also patriarchal, as we know, most tribes. So that's something that you may think about at least. With regard to laws that we have, India that I know better than in most others, there is in the Stri Dharma that you talked about, the Dharma with regard to women, there are elements of it that consider women as subjects, and therefore, for example, there's the thing about what the status of a woman is who have gata pratyagata, a woman who has left the husband, gone to someone else, and then come back to the previous husband. Now, this opens up the whole new world that a woman actually could go on her own will and run off with another man, and then have second thoughts and come back, right? So here we have just like a deer that you're talking about earlier, not coming back to the owner, so-called owner. So you have this whole thing, and then there's a whole section of Indian legal procedure which have to do with disputes between husband and a wife. Mm-hmm. So here we are talking again about the ability of a woman to confront the husband within the context of these laws. So there are small areas where patriarchy doesn't seem to be, totally oppressive, but there are few and far between, I think. Yeah. Caroline. Anybody?
Tim, do you want to go next?
I agree with what Patrick's saying. The Dharma Shastra is a overall a very fully patriarchal system. What you can see is situations like what Patrick was talking about, where you can sort of read between the lines and see that there's more going on there than they're acknowledging. I mean, the other thing that I would point to, I emphasized at the beginning that it's very important to look to documentary records. For India, this is extremely limited, and generally later, sometimes so late that they're not technically ancient documents, at least by the chronology that we established for the project. But nevertheless, I mean, for instance, there's an enormous amount of records, particularly from South India, of women making religious donations in their own name, in their own right, which shows, you know, a lot of agency that would be otherwise, I think, invisible to us. So it gives you an idea of what's going on beneath the surface of the male-authored, elite male-authored Dharmashastric text, which is the vast bulk of what we've got available to us. I mean, by the same, I mean, you're asking about gender in particular, or about women's roles in particular, but I mean, there's also similar documents where we can see, there's one in particularly that I wrote something about, of a shepherd, you know, getting one of these inscriptions made to protect his and his family, his own property rights, and to ensure that his children will inherit. I mean, this is the sort of person, just to go by, I mean, we don't know much about him. We don't know anything about him that's not in the document. But just by the status label shepherd, one would think that this is not the sort of person who is normally be expected to be having copperplate deeds executed. So it's clear that the resources were potentially available to those who could manage to make use of them. The one other point that I'd make is that, and again, it's very hard to find traces of this, particularly in certain parts of the world, but there are situations where even the disadvantageous, stigmatized or disadvantageous statuses can sometimes be sort of manipulated in a way to gain some sort of advantage out of them. The first thing that comes to mind, Sarah Bond wrote about infamia, this sort of disrepute, which is an official label that could be slapped on people for various reasons. It had Christians, after the Christianization of the empire, got labeled as infamous just because if they were heretical. But prostitutes, right, would be in that category. So then there's this gray area. What about the woman who runs the inn, where the barmaids are also entertaining the men with non-comestible entertainment? So a woman could be prosecuted for, Caroline should really be presenting this particular example, but could be prosecuted, as I understand, for adultery, unless she was infamous. The prostitutes were actually protected from prosecution because of who they were. So, and then there was a case that Sarah Bond mentions of actually a senatorial woman who tried to evade prosecution for adultery by registering herself officially as a prostitute. It didn't work apparently, but so there's certain ways in which, you know, being this system is in some sense stacked against you as a woman, as far as inhibiting certain sorts of rights and capacities that men would have. Likewise, well, actually, I'll leave anything else Greco-Roman for Caroline to take up.
So I was just going to add, I'm smiling because I know the law that you're talking about, Tim, and the really interesting kind of phrase from it. So it's from the reign of the Emperor Marcian, and it states that women who have no status to lose. So that again, to go back to the Patrick's point, is a double-edged sword, right? Because, you know, in terms of what we would term criminal prosecution, but what when the Roman system would mean, you know, a crime or a kind of violent action which could be prosecuted on behalf of somebody else within the community. If that happened to a woman of no status, then that crime wouldn't need to be prosecuted because she has no status. So her reputation doesn't need to be rescued. So my answer, I think, Shuvatri, and again, you know, Patrick's absolutely right. It's a brilliant question. I think status, so again, to go back to what Tim was saying, I think status is so crucial here. So to use that, you know, that kind of important modern concept of intersectionality, you know, I think we see that in the ancient societies too, right? If you are a woman and you are low status, it's game over. If you're a woman and you're of high status, there's stuff you can do, right? And you know, there are ways around, and you know, there are get-outs. So the leges iulii, as far as I understand from the Roman system, are very much targeted at those, you know, the 0.2% elite of society. And it's all bound up with property and inheritance. So I think that there would be a lot of connections and comparisons with the research that you're doing if you were to go back and to look at this period. But I really do think that it's about social status, to come back to sort of Tim's point from earlier, not just about gender. And as historians, we always have to think about those two things as interlinked. The other thing that I would just briefly mention is I remember reading the work of a scholar called Nathan Brown, who did a lot of research into 18th, 19th century Egypt. And he was looking at, you know, incredible amounts of records from 18th and 19th century Egypt to do with petitioning and who was actually going to the so-called, what we would call state courts in 18th and 19th century Egypt. And he proved that it was exactly the people who you wouldn't normally assume would have access. So it's the women, the marginalized. And obviously, when you think a little bit more about this, it makes sense because they are the individuals or the groups that couldn't get justice within the kind of, you know, dense social networks that they otherwise had to inhabit. And you can see exactly the same thing if you go back and look at those fragments of papyri, and I think that Patrick and Tim were mentioning before, from late antique Egypt. So it's the women and the marginalized individuals who saw Roman state power and tried to make use of it as a way of getting out of that, you know, perhaps even, I don't want to say more patriarchal, because I think patriarchy is a structure, you know, it's not that you have more or less of it, it kind of underlies everything, but that they saw an opportunity there, as Tim was saying, to try and do something. There's a brilliant, it's not gender related, but a wonderful law from the reign of the Emperor Constantine, early 4th century. And this one always sticks in my head. So it's I've mentioned this to Milinda before. It's a case where, and Roman law, by the time you get to the early 4th century, if you have 5 children, and you plead the fact that you have 5 children, you can get out of all kinds of public burdens, so public kind of munera, as they're called. And Constantine issues this ruling saying that it has come to his attention that people, and the term there is neutral, so we should assume men and women, have been presenting children other than their own in order to get the benefits of this exemption from munera. So that always sticks in my head. I think, you know, whenever you have systems in the way that we're looking at them, structures, there are individuals and groups who will attempt to work those systems and structures to their advantage. And whether that succeeds or not is part of the excitement of working with, you know, the archival records. And sometimes it works out and sometimes it doesn't.
Right. Kreshu, shall we hear from you? The next question?
Yeah, sure. So my next question is more about dialectic and kind of broader trajectories that you may or may not have noticed when comparing various traditions. So in Roman history, there's obviously an ongoing debate on the role of the people or populace in the Roman constitution. While the people was sovereign in theory, the Senate and the elites usually found ways to control the democratic element and achieve their ends, though there are significant exceptions. How does Roman law reflect the relationship between the people and the elites? The 12 tables are a famous benchmark for making law publicly available to different people and the continuing struggle of the plebeians to be included in the state institution and institutions, and not this obviously influenced their legal status. But would you say that Roman law developed in time to reflect this political negotiation to be more inclusive of different social elements? As I think, from what I understood, Timothy Lubin has argued that Hindu law was mostly in the hands of the elites, particularly the Brahmin elites, but developed over time to include a variety of different actors and reflected negotiation of various elements. is there anything by way of comparison that we can say in relationship to Rome that the law, the Roman law perhaps develops from the late Republic onwards to include various new social elements, such as the expansion of the Roman citizenship to include many new people?
I'll take that one very briefly and kind of bluntly. So I don't see that kind of, emancipatory struggle happening through the long course of Roman legal history. But I know that some of my colleagues who are Roman lawyers would definitely, accept that narrative. I don't, for a number of reasons. So I think that if we're thinking of Roman private law on which the kind of the civilian legal system is grounded, then we're thinking about relations between private citizens, and that Roman legal development sort of happens within that, I think, quite kind of circumscribed sense of, relationships between citizens. So I think that Roman law carries on all the way through up until the age of Justinian, being the law for the elite. Now I'm going to kind of backtrack on that for a moment, because of course, things happen, things shift and change, different kinds of, you get the rise of an entire imperial bureaucracy, from the late 3rd century, becoming formalized in a much more sort of specific way. So I'm not implying here that things stay static, but I don't think that we can, for example, the 212 CE, the Edict of Caracalla, as it's known, which so-called extended citizenship, I'm afraid I see that as a tax-raising measure. And I think it meant the Roman, being able to use Roman civil law became available to a much wider population than it had before, which is important. Whether that means that population was actually able to make use of the Roman civilian law to the same extent, I think is a completely other question. One way, though, that I would temper this, I think, is that if we come back to that relationship between law and religion, religion in the kind of modern sense, which I want to do air quotes and bracket, but if you're looking at the rise of institutional Christianity, as I have in a lot of my research between the 3rd and the sort of early 6th centuries, then I think that there is a huge amount to be said there about the democratization, again, to use another kind of modern concept, of Roman law, and what the institutional Christian church attempts to do with Roman law. So I think that is a conversation that could be had, but I don't so much buy the narrative of the struggle of the plebeians to be instituted in state institutions. I mean, one of the reasons as well is that narrative was really developed under the reign of the first emperor. So I think it's bound up with this notion of imperial power and what the constitutional framework, to use another modern term, of the sort of Roman Republic into the empire was supposed to be. So yeah, I think the Christian church is the way to go to really look at that question of law as dialectic, but it kind of veers off onto a different path from the one that I think you have in mind.
One quick note, I don't have much to say about this particular question, but I've written a small article a while back about the audience of the Dharmashastras. In other words, these people are writing these books. At whom implicitly were they directed? And there's interesting tidbits here. For example, describing how a person should welcome a guest. He should ask his servants, 2 of them, to come and wash his feet, and a room where he could sleep. Well, his implicit audience had servants at home, and had a house with many rooms. Right? Clearly, you're talking about a particular kind of individual at whom this was directed, I think. So yeah, this is what could call, in the Victorian way, a middle-class morality, here, that you're talking about in the Dharmashastras. Yeah. One to add to what Tim said with regard to the earlier question, a thing that a book I'm not sure whether you're aware of, Shuvatri, is Leslie Orr's book that was published in our series here by Oxford on the inscriptions of temple prostitutes and their donations, and prostitution or courtesans. They were the paradigmatic independent women and business women of ancient India. Yeah.
what I would say in this regard is that, first of all, if you're looking for the people being represented in ancient law, I mean, the reason it's hard to see is because, at least certainly is the case in India, most people's legal business was not handled by the high courts, right? It was handled in village, local, or caste or lineage forums. And that's largely in the sphere of unwritten law. I think I'm of the party that would say that this is still law, but in any case, we have precious little to go on to know what that looks like. However, what we do see is, again, in many of these, a small number of inscriptions have been preserved, like the Vishnu Sena charter that Patrick mentioned, where a particular group presents their, their own set of rules, regulations, to get the imprimatur of authority on. And I think that I can think of many examples of this from later periods of Indian history. Basically, what you get are situations where individual groups petition the king or petition whatever the local headman to allow them to continue to do what they've been doing, and to actually get the acquiescence of authority to support that and enforce it, perhaps. So one of the issues that comes up in religious law is that religious legal systems that aren't hand in glove with the state have no enforcement powers, but it's possible to get the state to take on that role if it's a negotiated thing. And I think all these references in the Dharma Shastra text to regional dharmas, right, to Desha Dharma that Patrick mentioned earlier, are basically there because, in a roundabout sort of way, certain groups petition to say, you can't tell us that what we have been doing, so for South India, it's this particular kind of marriage arrangement, cross-cousin marriage arrangement. You can't just say that that's not Dharma, So that's one of the ways in which we can see a little bit of it creeping back in, but it tends to be in very general blanket terms, right? It's only in a few places that we get specific examples cited.
Yeah. Thanks, Patrick, for that reference. I didn't know about it. I will look into it because, so my next question sort of has already been addressed in a way, because we've been talking about legal subjectivities and the way it can be gendered, actually. So the whole conversation on how prostitutes are sort of independent women, and Caroline's very insightful, thought-provoking, actually, the question of status, because I'm wondering how status turns into a question of class in much later modern times, because what we're referring to essentially as status in ancient times, I'm intrigued how much that has to do with class, and of course in the case of India, how much that has to do with caste, race in other cultural contexts. So again, to go back to the question of intersectionality, but to sort of keep it brief and tight up. So my question would be, in what ways can a comparative analysis of these ambiguities within the ancient legal literature that we've talked about so far help us conceptualize the different and yet very similar ways of gendering legal subjectivity? And we can start with Tim now, since it's always going in between. So maybe we can start with Tim now.
I don't know that I have anything to add that hasn't already come up in a way on legal subjectivity, on gendering of legal subjectivity. So I'm not excited to be the first to go in this instance. Does anyone else have a good answer for this?
I can add a tangential point, which I think is, may or may not be useful. I'm going to add it anyway. So I recently wrote a piece looking at kind of late antique ideas about heresy. And, you know, put very simply and bluntly, in the kind of Christian anti-heretical literature, and Sarah Bond, of course, has also looked at this, Tim, but in the Christian anti-heretical literature, that there is this tendency to think of the heretic as being the woman. So that, you know, the seductive, the temptress, all the way, you know, going back to Eve and all those kind of Judeo-Christian narratives. So heresy tends to be gendered, right, and it tends to be female. So my question when I went to the Roman sources, and I went first of all to the big imperial law codes of late antiquity, and then kind of looked at a couple of other juristic texts, was, is heresy gendered in the law? And my answer was no. Right, there is not a trace of gendered heresy when you find emperors making, I mean, you know, heretics are mad, bad, and dangerous to know, but they're not harlots as far as the Roman legal system is concerned. So again, I think it comes back in a way to this question of status. And when you look at heresy in the Roman legal system, what the emperors seem to be really concerned about is cutting off rights to property and, you know, trying to control how society was shaped, you know, how wealth was transmitted, how families were, you know, kind of put together, using the law as a way of kind of trying to back up religion. So the gendered question there, I mean, I'm kind of answering it by way of a negative, aren't I? I mean, I'd love to be proven wrong, but even when I looked at kind of legal accounts of trials against heretics, of which there are no more than a handful, the rhetoric there does not seem to be gendered in the way that the Christian literature of exactly the same time is strikingly heavily gendered. So I think that there's something interesting there, but I'm not entirely sure, even though I've written a paper on it, still what it is. But I hope that helps.
Picking up on your question with regard to the rituals of pativrata, right? Which is a generic term for a good wife who is devoted to her husband, who considers the husband as a divinity. Something keep in mind, of course, even though pativrata rituals may give some legal remedy for the widow. If you look at the Indian theology of inheritance, you find that the inheritance, in other words, the person who inherits a man's property is the one who is obliged to offer post-mortem rituals, the shraddha ceremonies to the person who has died, right? So in a sense, the wife can claim that by being the person who actually does those rituals. So it is again a patriarchy because the property follows the man to the next person who is connected to this man ritually after death. So it's an interesting aspect to that, I think. Yeah, but you know, yeah, you can't whitewash patriarchy out of the system, however much we may want to do that. Yeah.
Right. So should we hear concluding, summarizing thoughts from Milinda and then another round of responses, maybe?
Shuvatri, I was actually thinking, because we are running short of time, should I slightly modify my question or to give kind of my thoughts on some of the very interesting things that have come up, or do you think we'll have another round, or we have the time? What do you feel?
Depends on our respondents more than me, actually.
Okay.
Maybe.
Right. Maybe I'll just summarize some of the things that have been coming into my mind and combine that with my question. Yeah. So obviously the written formal question that I had asked you was about what all of these can tell us about decolonizing law and legal thought. And the concrete examples I gave were the queer rights movement in India, decriminalizing homosexuality, which comes out of subaltern queer activism. And the other one from the New Zealand Parliament, recognizing a particular river sacred to the Maori, seen as an ancestor, as a person with legal rights. And now to tie in with what you have been saying, this has been an immensely inspiring discussion. I have three main thoughts. The first thing, tying up with something both Timothy as well as Patrick mentioned, which I think that is very persuasive, and I will definitely be thinking about this a lot in my future work, the multiple polities or multiple territorialities of law. So let's say when my peasant Rajbongshis or the indigenous populations of Tripura are making law, the question whether it is law or not is a political question. If we consider the Rajbongshis as a polity, if we consider the indigenous people of Tripura as a polity, then of course what they are doing is lawmaking. Now, and then this is very fascinating example that Timothy mentioned and Patrick mentioned of Sreni Dharma. What they are then doing is, of course, I mean, in a way they're doing what 2000 years ago, your Sreni Dharma texts were doing. They're going to the state and saying, now let us do what we have always been doing. Let give us the autonomy over our territory, which is why in Tripura, 2/3 of the territory belongs to this indigenous population. And you have this very similar situation in northeastern India with the Nagas and so on. They're basically saying, recognize our Desha Dharma, recognize our Jati Dharma. And in a way, what the state, the post-colonial state is doing, when it is, including these kind of autonomous, basically polities for the scheduled tribe population, it is recognizing the Desha Dharma, the Jati Dharma of the Nagas and the Tripuris and so on. So one of my very good friends, Yele Butas, has a fantastic book on Naga democracy, where he talks about how in Nagaland, in the elections, the Nagas actually decide who the candidate will be, who will win. They don't believe in the person of one person, one vote. And they have this concept of community speech, community thinking, and they just want the Indian state to recognize that. And that is really fascinating, this kind of dynamic, the longue durée continuities of that, and what this means in terms of decolonizing law. Now, of course, I completely agree with Patrick that these indigenous communities are not necessarily more more emancipatory, but I think, I mean, I'm writing a pamphlet at the moment on revitalizing subaltern studies. And the kind of thinking that Yele and I, who are writing it, is doing is to say that what we need is more intersectional conversation, let's say between these indigenous populations, feminist thinking, environmentalist thinking, so that each of these polities now learn from each other to make their own kind of basically legalities, which will then hopefully be recognized by states, international organizations, and so on, because they will be more emancipatory than kind of capitalist legality or something. Two more very shorter points. One, I was thinking, Caroline's fascinating reference to the will of the deer. And I was thinking, of course, in a way, if we look at the whole structure of domestic animals, the very fact that there are things called domestic animals, the pashu, means we recognize that some animals can recognize us as different from others. So Yele works, for example, on the yaks in Bhutan, how the yaks in Bhutan know which human is their friend, and they will allow those humans to milk them. And other humans who are not their friends, they'll get a sound kick in the butt. So, I mean, the fact that animals can recognize who is, theirs and who is not theirs is, of course, at the basis also of Kave Kanem, that you can use dogs to protect your property because dogs know who the stranger is and who is not. And in a way, law implicitly or explicitly recognizes this. My last very quick comment was, and perhaps this is really something for a long discussion, because Patrick mentioned about Swa and Swatwa, which I've been thinking about a lot as well. And of course, you have very similar categories in the European tradition as well, with Sum, Mayum, and so on. And I'm thinking of Emile Benveniste's kind of really fascinating discussions about this potentially having longer Indo-European genealogies of the link between the self and possessions. And I was wondering what this means in terms of broader transcultural understandings of possessive selfhood, or to use Macpherson's terms, possessive individualism. So those were my very quick thoughts.
Shall we return to the original order and
Thank you, Milinda. The one thing that I would add is that it's something which just occurred to me kind of in thinking about this roundtable. So, when we're looking at ancient law, we are looking at ancient states and we're looking at ancient state polities. And it's really interesting. So the book that I'm currently finishing for OUP is pretty much doing, what you just picked up from what Tim and Patrick is saying. I'm trying to do that for the Roman Empire, right? To say that there are these multiple, and whether we call them polities or not, we need to take them seriously. And that if we go with the kind of the imperialism of Roman laws, it's normally understood, then these traces get kind of, removed. So I think that there is a story to be told there, rightly or wrongly, we'll see, for the Roman world, which is at least comparable to the kind of things that we've been discussing about the Indian world. But the one thing that I would sort of just contribute by way of by ending. So when we got the readers' reports back for the Cambridge Comparative History of Ancient Law project, one of them said, I think you're right not to try and do the ancient systems of the Aztecs or the sub-Saharan Africans, but you need some kind of justification as to why you're not doing that. So our justification was that in these volumes we are looking at this vast ancient Eurasian system of circulation. It involves populations, ideas, goods. So there's an economic system there. In the field that I work in at the moment, it's kind of becoming very trendy is to belittle it, but it's the mode, right? To try and apply modern institutional economics back to Roman law. And I think today, in preparing for this roundtable, I finally put my finger on what really bothers me about this. So we do have this massive, system of circulation, this Eurasian system. But what I don't think you would get in the ancient world is the debate that went on over the last year, in the newspapers, but also in parliaments, where, you would get people saying in the wake of the COVID-19 crisis, well, do we protect the neoliberal economic system, right? Because that's something external and autonomous, or do we save lives? As if somehow these two things. I think that would be alien. I don't think that I could walk up to a Roman and say to them, should we protect the economic system or should we save lives? And they would have a clue what I was talking about. So I think if we're thinking in terms of fundamental differences, I don't think it's the state that's the fundamental difference. That perhaps is still on a scale. It's the economics of it. And I think it's capitalist relations where the differences really lie. But I need to think it through more. Thank you.
Well, I would just respond to your mention of multiple polities, multiple sorts of polities, potentially overlapping polities. I mean, I've been toying with the idea of discussing the religious systems of law. Now, for antiquity, being an Indianist, that's why I really wanted to bring this issue in, because Hindu law is basically a religious system of law existing side by side with the much more hard to document polity laws of the individual polities of India, of which we've only got fragmentary evidence. But clearly there was an interaction going on between these. And we have Buddhist law, but Buddhist law is a religious system of law that's really entirely about the internal regulation of a religious organization. So it differs from Hindu law and from Dharma Shastra, if we want to call that Hindu law. In a fundamental way. And we've also got Jewish law in the sense of Talmud. And that was, there was some question even whether that belonged in the project, but we left out canon law, we left out Islamic law just simply on chronological criteria, right? But with all of these systems, which are very similar, maybe bracketing Buddhist law a little bit there, as much as I do think it really is law. The issue here, but actually it does apply here as well, is that these are basically, what I refer to as trans-regional legal regimes, and that we're dealing with a situation of legal pluralism here, where I think that the sorts of stuff that you're studying, Milinda, could also come into play. So basically that religious law and customary law are alternative structures that are not tied to a particular state. They're not even necessarily tied to a particular locale or region, although in the case of customary law, often they are as well, at least insofar as the people occupy that region. But nevertheless, I see some analogies here between, well, basically it poses some of the same sorts of problems that international law pose in the modern world. Like, what is the, remit of international law? What is the enforceability of religion? So you talk to, hard-headed law people, and, I can think of one person in particular who basically thinks that international law is just a mind game, it's just wishful thinking, and that it doesn't really exist, because ultimately it all comes down to the law of the state. But, right, I think it's in this, the religious law is basically operating in the same way. And we know that actually it does have teeth. It does bite in the sense of people follow or make an effort to follow. And there are consequences for them if they don't, even if those consequences don't include incarceration.
Well, I don't have much to add, but let me also, following on Tim, about the trans-regional aspect of certain kinds of laws. Actually, the main term that's used for Indian law, the term dharma, is intrinsically trans-regional. It is non-state based. It is not connected to any particular kingdom, right? So you have there within it a it may be broadly culturally contextualized to be the Indian, right? But not particular. The second point about, several of you have asked, Milinda too, about the New Zealand Parliament recognizing a particular river, etc. And I think Indian legal systems are quite a good example of assigning legal personality to non-human beings, be it a statue, a temple, or even a natural phenomenon, based especially on their sacred nature. There is something special. It's almost a little bit like the Japanese view of a particular tree, having the nature of kami, and then that having, you can't just go and cut it down for timber, right? So that's not allowed. I think recently, I don't know, you probably know about this much more than I, about the Ganges being given a legal personality so that they can bring polluters to court. So that's an interesting thing. And of course, in the Indian, sacred landscape, various mountains and sacred rivers and pilgrimage sites called tirthas, they all have some amount of sacrality and therefore can be defended in the legal system, right? Even though they cannot themselves come and participate, they could have legal representatives going to court for that, I think. So,
yeah, and just to add on to that, I mean, a lot of those early religious endowment deeds were written with the deity or the Buddha as the recipient. So in that sense, that's who has a claim on, that's the owner of the property.
Right, absolutely,
yeah. Right. Right, this has been so thought-provoking, and thank you, all of you, for continuing the conversation well over time. We have a couple of questions from the audience. One I will read out because it has been typed out here. So this is for Caroline. And the question is from Wen, who was one of the participants yesterday, and she's a China specialist. And she writes, my question is related to Professor Humphries' insightful comments on decentering Rome. Once we don't follow Greco-Roman law as the default tradition to thinking about norm building, then should we also include other approaches to the thinking about norms? Here I am considering the category of ritual. For instance, throughout Chinese history, from antiquity to very recent times, ritual has been much more central and a productive side than law has been for theorizing and debating over norms, power, obligation, and justice. So how do you look at other philosophical meta categories of thinking about norms, such as rituals, in a framework of comparative studies outside the Mediterranean political traditions?
It's another superb question, and I'm going to answer it by way of anecdote. So again, when we were doing the kind of putting together the Cambridge Comparative History of Ancient Law, we have a religion chapter, and part of the thing I think we've already mentioned about the comparative history is that we didn't want this kind of Roman legal imperialism. So each chapter has a different lead writer who comes from a different, what we would call, a tradition or an ordering from the ancient world. So for the religion chapter, we have a specialist from the Near East who is the lead writer, and there were a number of, really quite heated debates about what to do with ritual, Tim's smiling, in the religious chapter. And the interesting thing was that these debates weren't just between the Near Eastern specialist and everybody else, they were between Near Eastern specialists. So my answer to this would be that I think that the kind of the methodological background that you bring to your research and the kind of frameworks that you adopt are so crucially important, because the idea that you go to this material cold and just kind of make sense of what is there is not something that we have found within the project. So, I think there is a great merit to, decentering. Oh, so this is going to come back on me, isn't it, Milinda? But decentering the idea of law full stop. I'm fully up for that. The idea that, norms can be even more binding than what we would, traditionally in the modern world think of as laws. But, so I'm completely up for that project. But I think it's also about looking to ourselves as individuals and thinking, okay, what perspectives do we bring to the material? Because it's not just dependent on, what tradition you're actually looking at. It's also dependent on what tradition you've been trained in and you're bringing to the material yourself. But fascinating question, thank you.
And we have another question from the audience. I would really request the comments and questions to be kept brief, because we have desperately run over time by this point. Yes.
Yeah, thank you so much for this wonderful session. And thank you so much, each and everyone, for presenting their thoughts and views. I have some questions or rather comments. Like Caroline was talking about status, which Shuvatri was talking about class stuff in the modern times. Yes, it's true, because in ancient times, we look about the status, we talk about Prabhavati Gupta, who was perhaps one of the most powerful ladies in the Gupta period, accessing resources and stuff. On the contrary, we see position of women in the Gupta Empire deteriorating. So Prabhavati Gupta in North India was an exception. Again, if we move on to Southern India, we see the queens of Satabhana dynasty having a lot of resources and properties under the position. So status definitely plays a very important role, and I think one should look into the status thing when it comes to ancient India, at least in case of South Asia. Now, a lot have been talked about animals and commodification of animals. So I have a question, I guess, to all the panelists over here. Like, when you're talking about commodification of animals, can't we also think about the change in the status of animals after the invention of iron, maybe? Because prior to the invention of iron, prior to the invention of, 6th century BCE, we see animals getting more importance in the society compared to anything else. But when the invention of iron, land becomes more important, and that brings the rise of Kshatriyas into the society, which again gives rise to two new challenging religious beliefs like Buddhism and Jainism. So when we talk about commodification of animals, I think we should also look into the changing status of the animals with time and space. And lastly, I think there are far more comments which I would like to make, but with the constraint of time, I'll keep it short, very short. And it's a suggestion to Professor Dr. Banerjee. Like, when we are talking about the Rajbongshis, and he has been talking about them as a marginalized community, as people who have been deprived of subalterns. So even if we talk about them as marginalized and subalterns in the modern concept, I think we should go back and analyze the genesis of these deprived communities and the role of religion and the state in identifying them as marginalized or subalterns. And when they are making laws, so somehow they are also trying to get legitimacy in the society. Instead of challenging the establishment, they are trying to create a parallel establishment where they are seeking legitimacy from the society. And simultaneously, this societies, all the Rajbongshis, the tribals, aboriginals, which have if I'm not wrong, correct me if I'm wrong, Professor Olliville, autonomous areas were always instructed to be left alone in the Arthashastra, where the king was instructed to not intervene within the political affairs of the Aboriginals. So how this situation, how this entire polity gets changed into the modern concept, the entire genesis should be studied. And I think that will make a very interesting project in the future. Thank you so much once again for this wonderful opportunity. And it was indeed a thought-provoking session. Thank you.
Lovely. That was a fascinating question and a set of comments. I apologize for having to keep it short, but can we have responses?
I don't know whether I have a response as such to the question about the Arthashastra and all that, people to be left. Yes, I think one thing to be recognized in ancient India is the fact that these separate dharmas of various groups, even though like in the Vishnu Sena, it is recognized or have the imprimatur of the king, they don't need to be. These were actually recognized as area domains of law that was there and that didn't need to be recognized by the law to be effective. Talking a little bit about the norms earlier, and I think it's so important that law enters human beings' lives at such discrete intervals, whereas norms are things that we do every day. 90%, 95% of what we do, we follow certain unwritten norms. That was the problem of Trump, right? He never broke a law, but broke every norm that was there, that followed. And so that for human beings, human society, I think those norms are a lot more important than laws.
If I can quickly jump in, because I mean, so one of the questions was directed at me. Thank you very much. I mean, that was absolutely brilliant set of questions and comments. Just two small points. I think you're absolutely right. I completely agree with you that at least in India, and I'm sure also in Europe, in the Roman world as well, there are these waves of intensifying commodification, reification of the non-human. I mean, even somebody like, I mean, Caroline would know this far better. Varro speaks about animals as being instrumentum semivocale. So they are semi-vocal instrument. It's not like they're completely mute. And I mean, with Kresho, I have been discussing kind of these, when did the Romans get more anthropocentric from possibly a more capacious understanding of the non-human in the European times and so on. Of course, with colonialism, with capitalism, as Caroline has also been mentioning, with colonial capitalism, the kind of degradation of non-human beings into pure commodities gets even more intensified, so that today in the global scenario, we talk about GDP, gross domestic products, economic assets, which basically just reifies the non-human into commodities. So I think you're absolutely right. And one book I've been very inspired by is Philip Descola's Beyond Nature and Culture, who gives a very kind of interesting historical as well as ethnographic waves of shifts of the commodification of the non-human. The other quick point with the Rajbangshis, absolutely, I would completely agree. I think we also need to problematize and destabilize the category of subaltern. The subaltern should not be seen as something like a primordial category that Rajbangshis have always been subaltern. To the very contrary, I mean, the Rajbangshis in the early modern period from roughly the 15th, 16th century helped in the emergence of the court state, which was a very important polity which resisted the Mughal Empire for a long time. They were part of a princely state. So, and they themselves would see themselves as Kshatriya. Whereas, of course, the post-colonial Indian state labels them as a scheduled tribe. So I think we need to think about subalternity in a very nuanced and situational and dialectical way, rather than just a kind of binary between elite and subaltern. And I think, to be fair, Ranajit Go also understood subaltern as a relational category, not as a very reified thing. And when we recognize that that people can be subaltern as well as sovereigns at the same time, that there is a duality possible. One can be sovereign and subaltern depending on which power structure we are talking about. So I would completely, in short, agree with you about nuancing those categories.
Caroline, do you want to respond briefly to the comment?
So just to say thank you very much, and also, if I can, to say thank you to everyone, the audience and all of the people who've been discussing these things. It's been a fantastic roundtable, and thank you, Shuvatri, on behalf of all of us for, you know, setting up such a lively and kind of open discussion. It's been great. Thank you.
Yeah, a lot of fun. Thanks.
Thank you.
That is for
Thank you very
everyone.
much to everyone.
And Caroline sort of did the honor of doing what I was about to do, which is thank everyone. Thank you, everyone, very much. Thank you so much. And this overflowed in time because it was so amazing and so thought-provoking and so engaging. And I really hope in post-pandemic times, you know, we can take this up in normal circumstances and follow this up with a dinner and drinks and all the fun things in life. But for now, thank you. This has been amazing. Thank you so much.
Thanks.